or may I read them again?
Yes.
Yes. Under the cabinet system of government as embodied in our constitution, the governor is the constitutional or formal head of the state, and he exercises all his powers and functions conferred on him by or under the constitution on aid and advice of his council of ministers, save in spheres where governor is required by or under the constitution to exercise his function in his discretion. It is a fundamental principle of English constitutional law that ministers must accept responsibility for every executive act. In England, the sovereign never acts on his own responsibility. The power of the sovereign is considered by the practical rule that the crown must find advisors to bear responsibility for his action. Those advisors must have confidence of the House of Commons. This rule of English constitutional law is incorporated in our constitution. The Indian constitution envisages a parliamentary and responsible form of government at the center and in the states, and not a presidential form of government. The powers of the governor as the constitutional head are not different. These two paras are quoted. What is missed from Samsher Singh is in my written submission at page 197. These two paragraphs. Your lordships are at page.
Other than those two paragraphs, nothing else is referred of Samsher Singh.
And this is what I'm now showing.
54 and 55 you want.
And it's a Samsher Singh is 7.
66.
Please see para 54 and 56. The provisions of the constitution, your lordship gets one. The provisions of the constitution which expressly require the governor to exercise his powers in his discretion are contained in articles to which reference has been made. To illustrate, Article 239(2) states that where a governor is appointed an administrator of an adjoining union territory, he shall exercise his functions as such administrator independently of his council of ministers. The other articles which speak of discretion of the governor are para so-and-so, so-and-so, 6th schedule, and article so-and-so, so-and-so. The discretion conferred on the governor means that as the constitution.
No. Whether you are on a fence or
Genuinely, personal opinion, one shouldn't take extreme position.
Who are you appearing?
Intervenable.
Interventions have been allowed on the first place. We are giving advice to the President of India. I think we
No,
should-
not we. The court is giving. Yes, yes. No, the 143 empowers only the court to give advice
then
to the president.
Then without your assistance, we cannot give our advice.
Assisting the court. We are not advising the governor. Yes.
May I just put this down because we can't see your lordships, Mullahs. We'll put it back, Mullahs, at the end of it.
Even the learned solicitor.
Yes.
We will not put it back as long as the CV goes on.
Your lordship, because here there is no petitioner and respondent. And genuinely, I'm saying this, my lord, without any other meaning. Mr. Sibbal, my lord, I'm looking forward to his arguments because he has been a parliamentarian. He has been an elected person answerable to the people. And my lord, we know
So he has been a person answerable to the parliament also.
Parliament, that's why I was coming to that he was also in the governance, and how it affects the governance when I come to, my lord, the question of judicial review or, my lord, justiciability. Because people, your lordships are aware, of late, my lord, since last 20-25 years, my lord, you cannot take a voter on a ride. They catch the elected people.
You cannot.
Take voters on a ride, which earlier used to happen. They catch you that I have this problem, you are not solving me. And that is why, my lord, I always say that irrespective of the color of the political party, an elected person cannot be denounced that he is just an elected person. And
But who says that?
I will show. I'll show who said that, my lord. I'll not going into. Your lordships have not said. Your lordships have not said, my lord. But I'm going to show that. But they are answering.
I have always said that
My lords have always said. I have
separation of power, and
this bench. I'm not referring to, my lord. When we say
I have so many times deprecated I have said that the judicial activism has to remain, but it should not turn into judicial terrorism or judicial adventurism.
terrorism or judicial
And
adventurism, my lord. That's Correct, my lords. And as rightly submitted by Mr. Shankar Nayan, we are to assist your lordships, my lord, and your lordships will give the opinion. My lord, so far as yesterday's argument, my lord, which I will not stretch it beyond it because I know your lordships have got, my lord, what is my interpretation
Yes,
of
yes.
Article 200, but I have tried to, my lord, kind of calibrate it, my lord, so that instead of, my lord, is better, my lord, explained by me the way I am reading it. And it's very easy chart, my lord. It would not sorry. My apologies. I thought I had given. Yes,
Share it.
I can share digital also. Share digital also. Rest of it is shared with on digital, this thing, for rest. Oh, your lordships, my lord, kindly, my lord, bear with me only for 5 minutes and I'll switch over to the next point. The governor shall declare, I'm not repeating declaration has its meaning. It's a constitutional declaration. He has 3 options. First, let us come to the first option, grant assent. Now, what are the facets of granting of assent? Lord, please see the left-hand side route which the governor can take. At the outset, he grants assent. The bill becomes an act. Correct, my lords? But he can defer grant of assent and take a decision to resort to the proviso, that is returning the bill to the House. That is the 4th option in the proviso. Bill is returned by the House to the governor with or without modification. Then he will have 2 options. Lord, if your lordships can. Then he will have 2 options. He can grant assent. That all right, my recommendations or whatever.
We have gone through the chart. These only debates what we argued yesterday.
My lord, but my lord, second, my lord, let me at the cost of repetition show what is second. Second is a withhold option, which in my submission is a standalone option, and it is a complete action of the constitutional functionary.
So according to you, Punjab has been wrongly decided.
Yes, my lord, but he has a choice. My lord, right side, at the outset, if he withholds for, my lord, reasons, my lord, which I have explained, something is so patently unconstitutional or something going against the nation or clearly in the first schedule, etc., then the bill falls through. Now the question was, instead of, this is where instead of comes. Instead of taking this route of at the outset withholding, resorts to the proviso instead of withholding. Then, my lord, it is returned to the House. And if it comes back, he will have 2 options, my lord. He will grant assent that, okay, I'm bound because I cannot now withhold because I have resorted to the proviso. Or he can reserve the bill for consideration of the president. My lord, third is there is one new element which, my lord, which I have, and there cannot be any dispute on this element. When he reserves the bill at the outset for the consideration of the president, for presidential assent, my lord, first can be in case of repugnancy. If he feels that it is repugnant to some central law, he will refer it. Second column, my lord, which is a bigger column, your lordships need not read. There are certain provisions in the constitution itself which mandates that if your state legislature is passing this law, mandatorily presidential assent is required. It's nobody's discretion, neither governor nor council of ministers, nobody. My lord, for example, Article 31(3), 31A, before amendment, then second proviso to Article 2, so and so, so and so, so and so. There are several provisions. Or any other reason, my lord, which he feels that I want to reserve it for the president. Lord, this is what my lords also, my lord, were pleased to, my lord, indicate. This is just to, my lord, calibrate it, my lord, and put it in a comprehensive manner. But all 4 options are independent of each other. At least 1, 2, and 3 are independent, with an option to resort to option 4, not a mandate to resort to, my lord, option 4 as decided in Punjab. So that is my case, my lord. Now, my lord, may kindly come to sir, the page number.
Second one is you can choose to resort to the pro. Put your arguments. You
No,
have
that argument is over. I'm coming to the next argument. Well, look, there are some judgments which I have cited, how proviso is to be interpreted, but I don't wish to cite it here. It's a fairly settled proposition and your lordships are fully aware. It is cited for ready reference.
very well-known phrase.
Yes, yes. My lord, so page 187. My lord, this is the second question, my lord, which I am addressing. The first part is over. 200 and 201 is over. Whether governor is bound by the aid and advice tendered by the council,
That is page number.
187, my lord, of my written submissions. So PDF page also same.
PDF page is the
Well, your lordships have
Yes.
PDF page or the physical file, my lord. I can accordingly. The PDF page is 94. Para 166, my lord. याद करो जब मैं आऊं तब याद करो जब वहां पे पहुंचू तब याद करो. Lord, the question is whether the governor is bound by aid and advice of the Council of Ministers, my lord. Lord, 163 I have read, my lord. I'll read the first part, 163(1), so that, my lord, for just immediate reference, there shall be a council of ministers with the chief minister at the head to aid and advise the governor in exercise of his functions, except insofar as he is by or under this constitution required to exercise his discretion or any of them in his discretion. Correct, my lords? So functions can be discretional, based on discretion, or as per aid and advice. My lord, what is the demarcation? That is the question, my lord, before your lordships, my lord. My lord, here, minimum, my lord, I'll skip what is not relevant, but the minimum constituent assembly debate, my lord, which is relevant for your lordships to consider the question, my lord, is at page 187, bottom. Lord, Mr. Kamath objected this discretion and it was answered by Mahavir Tyagi. Lord, please have a look at Mr. Kamath's objection. When you, sir, raised a very important issue the other day, Dr. Ambedkar clarified this clause by saying that the president is bound to accept the advice of his ministers in exercise of all his functions. But here, Article 143 vests certain discretionary powers in the governor. And to me, it seems that even as it was bad enough. But now, after having amended Article 131 regarding election of the governor and accepted nominated governors, it would be wrong in principle and contrary to tenets of principle of constitutional government, which you are going to build up in this country. It would be wrong, I say, to invest a governor with these additional powers, namely discretionary powers. I feel that no departure from the principle of constitutional government should be favored except for reasons of emergency, and these discretionary powers must be done away with. I hope this amendment of mine will commend itself to the House. Then, my lord, this argument is responded to by Sri Mahavir Tyagi, lord, which is here. I beg to differ from my honorable radical friends, Mr. Kamath and Professor Shibanlal Saxena. And I think the more powers are given to provinces, the stiffer must be the guardianship and control of the central in the exercise of those powers. That, in my view, we have now given up the idea, the old idea of creating autonomous states, and are now keeping a reserve of powers in the center, and we are going to have nominated governors. Those governors are not to be there for nothing. After all, we have to see that the policy of the center is carried out. We have to keep the state linked together, and the governor is the agent, or rather, he is the agency which will press for and guard the central policy. In fact, our previous conception has now been changed altogether. The whole body politic of a country is affected and influenced by the policy of the center. Take, for instance, subjects like defense involving questions of peace or war, of a relationship with foreign countries, of our commercial relations, exports and imports. All these are subjects which affect the whole body politic, and the provinces cannot remain unaffected. They cannot be let free of the policy of the center. The policy which is evoked in the center should be followed by all the states. And if the governors were to be in the hands of provincial ministries, then there will be various policies in various provinces, and the policy of each province shall be as unstable as the ministry. For there would be ministries of various types having different party levels and different programs to follow. Their policies must differ from one another. It will therefore be all the more necessary that there must be coordination of programs and policies between the state and the central government. The governor, being the agency of the center, is the only guarantee to integrate various provinces or the states. The central government also expresses its thought, itself, through the provincial states. Along with their own administration, they have also to function on behalf of the central government. A governor shall act as the agency of the center, and we'll see that central policy is sincerely carried out. Therefore, the governor's discretionary power should not be interfered with. Democratic trends are like a wild beast. Say what you will, democracy goes by the whims and fancies of parties and the masses. There must be some such machinery which will keep this wild beast under control. I do not deprecate democracy. Democracy must have its way, but do not let it degenerate into chaos. Moreover, the state governments may not be quite consistent in their own policies. Governments may change after months or years. With them will change their policies. The governors may change too, but the policy and instructions given by the center to the governors will remain practically unchanged. The more the powers given to the states, the more vigilant must be the control. The governor must remain as the guardian of the central policy on one side and constitution on the other. His powers, therefore, should not be interfered with. He is not for nothing. He is not just a showpiece. My lord, thereafter, your lordships may kindly turn the page, my lord. Pandit Thakur Das Bhargav, my lord, continues the discussion. Sir, I beg to propose the amendment of oppose the amendment of Mr. Kamath. Under Article 143, the governor shall be and in the exercise of his functions by the Council of Ministers. It is clear so far. मुझे देना ये कुछ कट गया है मेरा. Article 143, governor shall be aided in the exercise of his functions by a council of ministers. It is clear so far. I gave notice of an amendment which appears on the order page at so and so, which I have not moved. In that amendment, I have suggested that the governor will be bound to accept the advice of his ministers on all matters except those which are under this constitution required to be exercised by him in his discretion. My submission is that it is wrong to say that governor shall be a dummy or an automation. As a matter of fact, according to me, the governor shall exercise very wide powers and very significant powers too. If we look at Article 144, it says the governor's ministers shall be appointed by him and shall hold office during his pleasure. So he has the power to appoint his ministers, but when the ministers are not in existence, who shall advise him in discharge of his functions? There can be a vacuum. One ministry goes, another has not been installed. My lord, in that context,
Whenever there is a president's rule,
yes, yes, my lord.
there are advisors to the governor.
Correct, my lord. They're appointed by the center. But can we read further?
In the vacuum also, normally if one CM resigns, or if he loses a majority till the new CM takes, he acts as a caretaker chief minister.
No, sir. Kindly, my lord, have a look at this one. Suppose, my lord, the tenure has gone. The governor tenure doesn't go. The new election takes place. It is considered, my lord. And it is considered subsequently in judgments also. My lord, 7 judgment, my lord, considers this aspect. Then again, when the governor calls upon the leader of a party for the choice of ministers after a previous ministry has been dissolved, in that case, there will be no ministry in existence, and who will be there to advise him? Therefore, he will be exercising his functions in his discretion. It is wrong to assume that the governor will not be charged with any function which he will exercise in his discretion. Article 175 and 188 are other articles which give him certain function which he has to exercise in his discretion. That is Article 200, and 188 is emergency powers. My submission is that, according to me, the governor shall be a guide, philosopher, and friend of the ministry as well as people in general, so that he will exercise certain functions, some of which will be in the nature of unwritten conventions, and some will be such as will be expressly conferred by this constitution. He will be a man above party, and he will look at the ministry and government from a detached standpoint. He will be able to influence the ministers and members of the legislature in such a manner that the administration will run smoothly. In fact, to say that a person like him is a mere dummy, an automation, or a dignitary without powers is perfectly wrong. It is quite right that so far as our conception of a constitutional governor goes, he will have to accept the advice of his ministers in many matters. But there are many other matters in which the advice will neither be available, nor will be bound, nor will he be bound to accept that advice. My lord, thereafter, my lord, Dr. Ambedkar's speech, which I have read, my lord, in a different context. So, my lord, I am not reading it here, but he, my lord, substantially echoes the Mahavir Tyagi view and the view of Pandit Thakur Das. Now, my lords, may kindly come to Lord, I have quoted Sirvai, my lord. If your lordship can come to, I will not read it. Page 192. My lord, what are the discretionary powers of the governor and the president? My lord, Sirvai has, my lord, H.M. Sirvai has elaborately dealt with, my lord. I may not read it. Your lordships may kindly read it. It would, my lord, really assist your lordships. Now, please come to, my lord, 194. Lord, these are the judgments on the question of discretion. Lord, please see 188 at the foot of page 194. It is, your lordship gets that. It is 194.
What bottom?
194. PDF is 101. Para 188. It is submitted that this honorable court has carved out an exception to the general rule of the aid and advice, which is not expressly stated in the Constitution, however, which is in consonance with the intent of framers of the Constitution of India and also with the scheme of functions and powers of governor provided therein. A reading of the judgments discussed below and other provisions of the Constitution of India would show that inter alia, the following are the exceptions to the general rule of aid and advice, where the Constitution expressly provides for the same. For example, Article so and so, so and so, so and so, where he He will not be bound by the aid and advice, and there cannot be any dispute. These are constitutional mandates. B, where the legislative intent emerging from the interpretation of any provision of the Constitution, like the powers under Article 200, 356, or the power to dismiss the government which has lost confidence but refuses to quit, as has been mentioned in the report of Justice M.M. Punchi Commission, and have been concurred by a 5-judge bench of this Honorable Court in Nabam Rabia. I'll read, my lord, very illuminating paragraph of Nabam Rabia, where the Constitutional Court specifically declare that certain functions ought to be exercised by the governors on his own. My lord, your lordships have developed this law, my lord, by judicial decision making. Power to summon or prorogue the House of Legislative Assembly under Article 174 when there are strong reasons and material to show that incumbent Chief Minister and his Council of Ministers seem to have lost the majority of the House. Then situations or matters where the bias is inherent in the aid and advice of Council of Ministers, like the case of grant of sanction for prosecution of Council of Ministers. 197 sanction or Section 17 PC Act goes before the governor, my lord, in case of chief minister, then obviously he would not be guided by the aid and advice, and MP judgment, my lord, I'll show that makes it very clear. Now your lordships may kindly see, my lord. This is, my lord, Lord, I'll skip that judgment. Please come to 197, Samsher Singh. Samsher Singh, my lord, is a 7-judge bench judgment. At the outset, I may point out that Samsher Singh's 7-judge bench judgment is taken note of in State of Punjab versus Union of India, but the relevant paragraphs appears to have missed. It doesn't take care of the relevant paragraphs. I can, my lord, make that statement, my lord. If it is challenged, my lord, we can show it from the, it's not there, my lord. I can't, my lord, in State of Punjab versus Union of India, the 3-judge bench, my lord, 2024 judgment, takes note of Samsher Singh, but it has escaped the attention of the bench of these 2 paragraphs, which according to me is the real law of them. Lord, your lordships would find, my lord, that judgment at page 11669. Just put a note, my lord. That judgment, my lord, volume 5.29, judgment starts at page 11660.
Punjab volume?
Volume 5.29. At page, it starts at page 11660. Samsher Singh is cited at para 16.
Para 16.
16 at page 11669.
1 minute.
Not only 2 paragraphs are noticed. The lordships may come to 11669. My Lord Justice Narasimha has, my lord. Para 16, my lords have. My Lord the Chief Justice.
Does it start from 11660?
It starts from 11660, but I am at 11669, where Samsher Singh is noted. These principles have been well established, your lordship gets, my lord, since the decision in Samsher Singh versus State of Punjab, where this honorable court held, under the cabinet system of government as embodied in our constitution, the governor is the constitutional or formal head of the state, and he exercises all his powers and functions conferred on him by or under the constitution on the aid and advice of his council of ministers, save in spheres where the governor is required by or under the constitution to exercise his function in his discretion. It is a fundamental principle of English constitutional law that ministers must accept responsibility for every executive act. In England, the sovereign never acts on his own responsibility. The power of sovereign is considered by the practical rule that Crown must find advisors to bear responsibility for his action. Those advisors must have the confidence of House of Commons. This rule of English constitutional law is incorporated in our constitution. The Indian constitution envisages a parliamentary and responsible form of government at the center and in the states, and not a presidential form of government. The powers of the governor as the constitutional head are not different. My lord, these paras are quoted. What, my lord, your lordships have, my lord Justice Suryakant has the right copy, my lord, I believe.
Supposed to be.
I thought so, my lord. My lord, volume Roman 5, 29.
From Allahabad, there is nothing there. नहीं 11,670 पेज खोलिए.
My lord, can I give my copy for immediate reference? My lord?
ये नहीं मिल गए.
State of Punjab governor.
No, like, yes, go to
My lord, 11669,
paragraph 16.
paragraph 16, my lord, I'm grateful. My lord, where
Shamsher Singh.
Samsher Singh is noted, para 28 and 32 are quoted, my lord, which I read. May I reread it, my lords? Or may I my lord, read them again?
Yes.
Yes. Under the cabinet system of government as embodied in our constitution, the governor is the constitutional or formal head of the state, and he exercises all his powers and functions conferred on him by or under the constitution on aid and advice of his council of ministers, save in spheres where governor is required by or under the constitution to exercise his function in his discretion. It is a fundamental principle of English constitutional law that ministers must accept responsibility for every executive act. In England, the sovereign never acts on his own responsibility. The power of the sovereign is considered by the practical rule that the crown must find advisors to bear responsibility for his action. Those advisors must have confidence of the House of Commons. This rule of English constitutional law is incorporated in our constitution. The Indian constitution envisages a parliamentary and responsible form of government at the center and in the states, and not a presidential form of government. The powers of the governor as the constitutional head are not different. Well, these two paras are quoted. What is missed from Samsher Singh is in my written submission at page 197. Well, these two paragraphs. Your lordships are at page.
Other than those two paragraphs, nothing else is referred of Shamsher Singh.
And this is what I'm now showing.
54 and 55 you want to.
And it's a Samsher Singh is 7.
66.
Well, please see para 54 and 56. The provisions of the Constitution, your lordship gets one. The provisions of the Constitution which expressly require the governor to exercise his powers in his discretion are contained in articles to which reference has been made. To illustrate, Article 239(2) states that where a governor is appointed an administrator of an adjoining union territory, he shall exercise his functions as such administrator independently of his council of ministers. The other articles which speak of discretion of the governor are para so-and-so, so-and-so, 6th schedule, and article so-and-so, so-and-so. The discretion conferred on the governor means that as the constitutional or formal head of the state, the power is vested in him. In this connection, reference may be made to Article 356, which states that the governor can send a report to the president that a situation has arisen in which the government of the state cannot be carried on in accordance with provisions of the Constitution. Again, Article 200 requires the governor to reserve for consideration any bill which, in his opinion, if it became law, would so derogate from the powers of the High Court as to endanger the position which the High Court is designed to fulfill under the Constitution. Now, 55. In making a report under Article 356, the governor will be justified in exercising his discretion even against the aid and advice of the Council of Ministers. The reason is that the failure of constitutional machinery may be because of the conduct of the Council of Ministers. This discretionary power is given to the governor to enable him to report to the president, who, however, must act on the aid and advice of Council of Ministers of the center in all matters. In this context, Article 163(2) is explicable that the decision of the governor in his discretion shall be final and the validity shall not be called in question. The action taken by the president on such a report is a different matter. The president acts on aid and advice of Council of Ministers in other matters where the governor acts in his discretion. He will act in harmony with his Council of Ministers. The Constitution does not aim at providing a parallel administration within the state by allowing the governor to go against the advice of Council of Ministers. Now, please see 56 is important. Similarly, Article 200 indicates another instance where the governor may act irrespective of any advice from the Council of Ministers. In such matters where the governor is to exercise his discretion, he must discharge his duties to the best of his judgment. The governor is required to pursue such course which are not detrimental to the state. My Lord, now I'll come to that, my Lord, and my learned friend also will take assist your lordships on that. My Lord, in the judgment of Tamil Nadu, this is my Lord, distinguished by the Honorable two-judge bench, my Lord, relying upon a concurring opinion in this seven-judge bench judgment, my Lord. One paragraph of the concurring judgment, I'll come to that. Now, my Lord, next judgment is MP Special Police Establishment Act. Again, my Lord, 5 judges, and was not noticed by the state of Punjab judgment. Para 11, I'll skip, my Lord, the first part. First part gives the facts. What were the facts of that case, my Lord, which may not be relevant for the present, but I have put it, my Lord, for ready reference. Para 11. Mr. Sorabji submits that even though normally the governor acts on the aid and advice of Council of Ministers, but there can be cases where the governor is, by or under the Constitution, required to exercise his functions or any of them in his discretion. The Constitution of India expressly provides for contingencies, my Lord, so-and-so, so-and-so, so-and-so. However, merely because the Constitution of India expressly provides, in some cases, for the governor to act in his discretion, can it be inferred that the governor can so act only where the Constitution expressly so provides? If that were so, then subclause 2 of Article 163 would be redundant. A question whether a matter is or is not a matter in which the governor is required to act in his discretion can only arise in cases where the Constitution has not expressly provided that the governor can act in his discretion. Such a question cannot arise in respect of matters where Constitution expressly provides that the governor is to act in his discretion. Article 163(2) therefore postulates that there can be matters where the governor can act in his discretion even though the Constitution has not expressly so provided. Mr. Sorabji relies on the Shamsher Singh versus State of Punjab. A 7-judge bench of this court inter alia considered whether the governor could act by personally applying his mind and or whether under all circumstances he must act only on the aid and advice of councillors ministers. It was inter alia held as follows. My Lord, para 54 to 56.
Which you just read.
Which I just read, which, my Lord, appears to have escaped the attention of the bench in state of Punjab. Now, my Lord, again, MP judgment again starts. Thus, as rightly pointed out by Mr. Sorabji, a 7-judge bench of this court has already held that the normal rule is that the governor acts on the aid and advice of Council of Ministers and not independently or contrary to it. But there are exceptions under which the governor can act in his own discretion. Some of the exceptions are as set out here in above. It is, however, clarified that the exceptions mentioned in the judgment are not exhaustive. It is also recognized that the concept of governor acting in his discretion or exercising independent judgment is not alien to the Constitution. It is recognized that there may be situations where, by reason of peril to democracy or democratic principles, an action may be compelled which from its very nature not amenable to ministerial advice. Such a situation may be where bias is inherent and or manifest in the advice of the Council of Ministers. My lord, this judgment of MP, five judge bench, my lord, is my lord, not considered, my lord. It has escaped the attention. Now I come to, my lord, most important judgment, Nabam Rebia, a relatively recent judgment, my lord, Arunachal Pradesh, my lord, issue. My lord, I must say, this is again, my lord, not, my lord, it has escaped the attention of the bench in state of Punjab. It was placed for consideration in Tamil Nadu judgment, my lord, but it quotes some paragraphs, Tamil Nadu judgment, but para which I am going to read, my lord, again has missed the attention of the bench, my lord. Kindly see, my lord. Similarly, in Nabam Rebia, para 151, 152, the Honorable Court referred to the Punchi Commission's formulation that governors' discretionary powers include to give assent or withhold or refer a bill for presidential assent under Article 200 and expressly endorse and adopt it. It was held as under. But 151, the important observation in Justice M.M. Punchi Commission report with reference to Article 163(2) are contained in para 4.5. The relevant extract in the extract of the same is as under. Article 163(2) gives an impression that the governor has a wide, undefined area of discretionary powers even outside situations where the Constitution has expressly provided for it. Such an impression needs to be dispelled. The Commission is of the view that the scope of discretionary powers under Article 163(2) has to be narrowly construed, effectively dispelling the apprehension, if any, that the so-called discretionary powers extends to all the functions that the governor is empowered under the Constitution. Article 163 does not give the governor a general discretionary power to act against or without the advice of his Council of Ministers. In fact, the area for exercise of discretion is limited, and even in his limited area, his choice of action should not appear to be arbitrary or fanciful. It must be a choice dictated by reason, activated by good faith, and tempered by caution. The governor's discretionary power are the following: to give assent, this is Punchi Commission. The governor's discretionary powers are the following: to give assent or withhold or refer a bill for presidential assent under Article 200, the appointment of chief minister under Article 164, dismissal of government which has lost confidence but refuses to quit since the so-and-so, so-and-so, so-and-so. Now, my lord, Nabam Rebia, five-judge bench again, my lord, quotes with approval this observations and says, we are of the considered view that the inferences drawn in the judgment MC Punchi Commission report extracted herein above are in consonance with the scheme of the functions and powers assigned to the governor with reference to the executive and legislative functioning of the state, and more particularly with reference to the interpretation of Article 163. We endorse and adopt the same as a correct expression of constitutional interpretation with reference to the issue under consideration. My lord, if your lordships were to see, my lord, how this is dealt with in Tamil Nadu, volume 31, my lords. This is 151, 152. Lord, this Nabam Rebia is missed in Punjab judgment. Tamil Nadu judgment takes note of it. But please see, my lord, so far as these two paragraphs are concerned, my lord, that again has missed the attention of the bench, my lord, in Tamil Nadu, my lords.
Which para?
my lord, page 12432, para 301. The lordship gets, my lord.
Yes.
11301. Lord, another constitution bench of this court in Nabam Rabia had the occasion, my lord. Thereafter,
One page number?
I'm sorry, 12432,
Yes. Paragraph
12432.
Yes.
Para 301. Another constitution bench of this court in Nabam Rabia. Nabam Rabia is, my lord, taken note of. Then, my lord, the honorable court is pleased to quote 140, para 147.1, 147.2, 148, 149, and at page 12435, Lord, possibly misses 151 and 152, which I read, and comes to 154. And this discussion in Tamil Nadu is directly while dealing with the question of discretion. These two paragraphs, my lord, since, my lord, it escaped the attention of the two-judge bench, my lord, I am placing for your lordship's consideration. Now, my lord, I come to the next judgment, that is B.K. Pavitra. But this is two-judge bench judgment, which is declared.
Just 1 minute. Come back to page 12432. The Tamil Nadu judgment refers to paragraphs 147, 148, 149, and then it jumps to paragraph 154. 151 and 152 are left out.
That's what I submitted, my lord, with profound respect. That two paragraphs seems to have escaped the attention of the bench, my lord. Because from 149, it directly goes to 154. And in my submission, the real law is laid down in 151 and 152. And this is, my lord, while discussing discretion, the point which I am arguing, my lord, whether in all cases aid and advice is binding or there is a room for discretion.
Yes.
Lord, now please come to page 200 of my submissions, my lord. B.K. Pavitra judgment. Lord, this issue was squarely there.
Can you
This-
read 154 with Tamil Nadu refers to underline
only a minute.
which comes after 152. They same very page. 154 of Tamil Nadu follows 151 and 152.
This is Nabam.
He's contained that though.
Lord, 154 is Nabam.
वो दो missing.
चार paragraph
बाद में
151 and 150.
Lord, 154 is slightly different from 151, 150. It is not slightly, but not substantially. Lord, now kindly come to B.K. Pavitra. Page 200. This is, of course, a two-judge bench judgment, but it is declared per incurium. And I'm not repeating the argument, my lord, but this itself was sufficient enough for a reference under 145.3. Lord, apropos your lordship's very correct, my lord, the proposition, my lord, the Chief Justice says at the outset that in every matter we are not supposed to look at 145.3.
But as far as justiciability is concerned, paragraph 155.5, Evam Revia.
Yes, but 155 will have to be read in context of 151,
Yes,
150.
but then even you read 155.5.
Fifthly,
Page 1 to
the underlined portion, highlighted part. Fifthly, the submission advanced on behalf of the respondents that the exercise of discretion under Article 163(2) is final and beyond the scope of judicial review cannot be accepted. Firstly, because we have rejected the submission, but this is on judicial review, not on discretion. Rejected advance by the respondent that the scope and extent of discretion vested with the governor has to be ascertained from Article 163(2) on the basis whereof the submission was canvassed. And secondly, any discretion exercised beyond the governor's jurisdictional authority would certainly be subject to judicial review. It was on judicial review. And it is, if it is beyond, but obviously, if governor.
According to you, under 200, he has an ample discretion.
That's
And
what
therefore-
Nabam Rebia says, Manoj. And Manoj, that's my contention. He has ample discretion, Manoj. Situations may differ. The instances which are given in all the judgments are illustrative, not exhaustive. But they say that it is wrong to say that in every matter, like precedent, he is bound in every matter by aid and advice of the Council of Ministers. Samshay Singh also, Manoj, 7-judge bench says that there are discretionary areas, including Article 200. Specifically, Article 200, every constitution bench mentions. That was precisely, my lord, the question in Tamil Nadu. I'm not, my lord, deviating from this point, but, my lord, just to, my lord, kind of respectfully respond, my lords have very rightly said that in every case, it's not necessary that the court would examine 145(3). A bail petition comes, it would involve Article 21, but it won't become a constitutional interpretation question that it has to be referred to the larger bench. But this was a case where only issue was constitutional interpretation. Facts were not, my lord, much in dispute. Anyway, my lord, leave it at that. Please come to BK Pavitra. My lord, para 66. This is, my lord, declared to be per incurium by the 2-judge bench, my lord, in Tamil Nadu. I'll show, my lord, that. Where a bill is not a money bill, your lordship gets. Where a bill is not a money bill, the governor may return the bill for reconsideration, upon which the House or Houses, as the case may be, will reconsider the desirability of introducing the amendments which the governor has recommended. If the bill is passed again by the House or Houses, as the case may be, the governor cannot thereafter withhold assent. The second proviso to Article 200 stipulates that the governor must not assent to the bill, but necessarily reserve it for the consideration of the president if the bill, upon being enacted, would derogate from the powers of the High Court in a manner that endangers its position under the Constitution. Save and except for bills falling within the description contained in the second proviso, where the governor must reserve the bill for consideration of the president, a discretion is conferred upon the governor to follow one of the courses of action enunciated in substantive part of Article 200. Aside from bills which are covered by the second proviso, where the governor is obliged to reserve the bill for consideration of the president, the substantive part of Article 200 does not indicate specifically the circumstances in which the governor may reserve a bill for consideration of the president. The Constitution has entrusted this discretion to the governor. The nature and scope of the discretionary power of the governor to act independent of or contrary to aid and advice of Council of Ministers under Article 163 was discussed in Nabam Rebia versus so-and-so, where, my lord, 154 is quoted. My lord, I've read, I'll skip that. Then para 67 of BK Pavitra. The framers carefully eschewed defining the circumstances in which the governor may reserve a bill for a consideration of the president. They did not give instances, they left it open-ended. By its very nature, the conferment of power cannot be confined to specific categories. Exigencies may arise in the working of the Constitution which justify a recourse to the power of reserving a bill for the consideration of the president. They cannot be foreseen with the vision of a soothsayer. The power having been conferred upon a constitutional functionary, it is conditioned by the expectation that it would be exercised upon careful reflection and for resolving legitimate concerns in regard to the validity of the legislation. The entrustment of a constitutional discretion to the governor is premised on the trust that the exercise of authority would be governed by constitutional statesmanship. In a federal structure, the conferment of this constitutional discretion is not intended to thwart democratic federalism. The state legislatures represent the popular will to those who elect their representatives. They are the collective embodiment of the will. The act of reserving a bill for assent of the president must be undertaken upon careful reflection, upon a doubt being entertained by the governor about the constitutional legitimacy of the bill which has been passed. Article 200 contains the source of the constitutional power which is conferred upon the governor to reserve a bill for consideration of the president. Article 254(2) is an illustration of the constitutional authority of the governor to My Lord Justice Suryakant has the same file. Article 200 contains the source of the constitutional power which is conferred upon the governor to reserve a bill for consideration of the president. Article 254(2) is an illustration of the constitutional authority of the governor to reserve a law enacted by the state legislature for consideration of the president in a specified situation where it is repugnant to an existing law or to a parliamentary legislation on a matter falling in the concurrent list. Eventually, which is specified in Article 254(2), does not exhaust the ambit of the power entrusted to the governor under Article 200 to reserve a bill for consideration of the president. Apart from repugnancy in matters falling in the concurrent list between state and the parliamentary legislation, a governor may have sound constitutional reasons to reserve a bill for consideration of the president, apart from the repugnancy issue. Article 200 in its second proviso mandates that a bill which derogates from the powers of the High Court must be reserved for consideration of the president. Apart from bills which fall within the description set out in the second proviso, the governor may legitimately refer a bill for consideration of the president upon entertaining a legitimate doubt about the validity of the laws. By its very nature, it would not be possible for this court to reflect upon the situations in which the power under Article 200 can be exercised. This was noticed in the judgment of this court in Hext, so and so. Lord, I'm sorry, I'm always confused with this pronunciation. Excluding it from judicial scrutiny, the court withheld. My Lord, I have read this, my Lord, when I read Hext, my Lord, so I'll not. Yes, my Lord. I'm not reading it, my Lords. Now, your Lordship, my Lord, kindly come to, my Lord, this point is over, my Lord. My Lord, there are some issues, my Lord, which we have divided with a view to save time, my Lord. My learned friend also would assist your Lordships, would supplement without, my Lord, repeating, my Lord. They would be able to more and effectively assist your Lordships. My Lord, kindly come to 204.
In a louder manner.
Yes, sir.
Both of them.
No, anything remains, no, not survives. Yes, sir.
We'll have to put off the wife.
Yeah, yeah. There was an interesting incident. I'll not share it here. My Lord Justice Narasimha, me and my colleague, my Lord, we went to Pune for arguing one matter, my Lord. Before NGT Pune, my Lord. But I'll some other day, not in the matter. Lord, question number, page 204.
Why are you unnecessarily telling about exactly?
No.
Either you should have not mentioned.
Now we have
Or
mentioned
if you have mentioned, you mention it fully.
Yes.
Unless it is not embarrassing to my learned brother.
No, it's not, my Lord, embarrassing to his.
So what happened in NGT Pune?
Lord, I'll just say with his permission.
Not let you proceed.
No, I'll say that.
You can't stop halfway.
Lord, I'll say that with permission of my learned friend and with an apology. It's not intended to insult. Lord, NGT Pune is a small courtroom. It's like a little slightly bigger bedroom. It's in a government building. My learned friend, all of us were on the same side. He was arguing, Lord, in his own way. Justice Kingaonkar,
In his own volume.
yes, Justice Kingaonkar was presiding over the bench.
Yes.
So at some stage, he did like this. So my learned friend understood that the honorable judge is unable to cope up with my speed. So he continued the same volume, but reduced the speed. Then I requested my learned friend that the trouble is with the volume, not the speed. And the judge complimented me by saying that, thank you, you prevented Punjab Mail. Sorry, but he's like my brother, my lord. I can take this liberty. My lord, my lord, page 204. My lord, this is, my lord, something very, very serious, and your lordships may take this, my lord, into consideration. One constitutional organ prescribing time limits for another constitutional organ. My lord, I can, my lord, I have no quarrel and I will never argue, my lord, and I'll pitch my argument that statutory functionaries can be bound by a time limit. The deputy collector deciding to grant or withhold non-agricultural permission. But would it apply to constitutional functionaries which are coordinate constitutional functionaries? My lord, these are the two questions, my lord, which are question number 5 and question number 7. My lord, I have incorporated, my lord, the debate which I have already read. In one line, I may just refresh your lordship's memory. Wherever time limit was stipulated at the time of drafting of the constitution, the time limit was deleted. And in that very provision, wherever time limit was required, time limit is added. So constitutional framers are very conscious of the fact that some functions need a time-bound exercise of power and some functions needs a kind of leeway, and we may not bind the constitutional functionaries with the power. My lord, please come to page 208, and I'm not going to read this, only for your lordship's assistance at page 209. My lord, I have compiled the constitutional provisions where constitution itself stipulates the time limit. I'm not reading it, but just with a view to see that your lordships gets it, at one place. 209, Article 22, Article 62, etc., my lord, the list goes on till at page 224. Wherever the Constitution has thought it appropriate for the object which that particular provision seeks to achieve, the Constitution provides for a time limit. Wherever the Constitution has, framers have considered. Yes, my lord, kindly note one more thing. Tamil Nadu judgment, which mandatorily stipulate time limits for the Honorable President and the Honorable Governor, relies upon the report of Punchi Commission and Sarkaria Commission. It itself says at the end, and obviously so, that these are our recommendations and we recommend suitable constitutional amendments. Meaning thereby, the reliance on the report itself, my lord, in my respectful submission, may not be correct, because Commission does not say that do it by way of a judicial adjudication. It has to be, my lord, logically. I don't have to stretch this point any further. If a commission is appointed by the central government of the day will consider whether to bring it by way of an amendment or not. But very interestingly, my lord, a converse situation has arisen. My lord, in one judgment, which your lordships would find at page 231, where one organ of the state, namely the legislature, provided for the time limit for another organ of the state, namely the judiciary. And matter went before, my lord, 7 judges bench. And your lordships would find the judgment at page 231.
238.
231.
Paragraph 238.
My lord, I'm sorry, my lord. One fact, my lord, I missed. My lord, there are judgments which I have cited from page 224 to 231 that even in statutes, court cannot add words, supplement words, or delete words. Lord, the leading
Except
judgment.
passes omissus.
Yes, my lord. It is conscious omission. And even if the court were to do it, court can suggest that we recommend or we suggest that the competent legislature may exercise its amending power, either constitutional provision or so. But my lord, one judgment, which is I'm not reading, page 228. 228 is the judgment, my lord, where my lord Justice Narasimha was also, my lord, on the bench. Suprio versus Union of India. Lord, this is a 5-judge bench, but I found, my lord, that it is not reportable. It has not been reported anywhere, my lords. So this was that right of LGBT community, my lord, my lord, seeking, where, my lord, the court said that we cannot read words into the statute. My lord, this judgment remains unreported. Thereafter, there are 2 judgments which relies upon this judgment, and those 2 judgments, my lord, including electoral bond, they are reported. But this judgment, my lord, remains unreported. As a matter of fact, that's all. Otherwise, my lord, it's a leading landmark judgment, my lord, laying down several issues of seminal constitutional importance, my lord, not only for the country, but for the society. I leave it at that. My lord, page 231.
Yes.
Page 231, my lord. When, my lord, legislature, my lord, provided for timeline for the judiciary. This is where, my lord, we say the separation of powers, constitutional committee between or amongst 3 or coordinate organs of the state. In P. Ramchandra Rao versus State of Karnataka, Lord, that is 7 judges, has been held that time limits for criminal trials cannot be prescribed. Lord, your lordships would see, sometimes facts may justify time limit, but justification does not confer jurisdiction. We may come across a situation where we feel that it is fully justified, that some time limit should be done. But if there is no jurisdiction, there is no jurisdiction. Justification can never confer jurisdiction. Well, let's see, kindly see, my lord, what the 7-judge bench is pleased to observe when one organ fixes time limit for the other. My lord, incidentally here, it's a converse. Legislature fixing it for the judiciary. Para 225, my lord, of this judgment I have quoted. During the course of its judgment, also the Constitution bench made certain observations which need to be extracted and reproduced. But then speedy trial or other expressions conveying the said concept are necessarily relative in nature. Kindly pause here for a minute. There are several considerations: lack of staff, lack of my lord, the burden of cases,
Depending
several
on the case.
considerations.
Depending on case to case, like.
Case to case, some case may take longer, some
Bomb
case
blast case, there might be 200, 300 witnesses.
witnesses. Lord, that is the justification. Lord, why I am pausing here? Lord, in case of decisions of the nature which governor or the president takes, They are polycentric decisions. They are not ticking the boxes that yes, complied with, complied with, complied with. There are they may decide, they may choose to call the governor, choose to call the chief minister. They may take some other consultative process to ensure that there is no impasse, etc., etc. And therefore, there may be several reasons for the delay. One may ask, speedy means how speedy? How long a delay is too long? We do not think it's possible to lay down any time schedule for conclusion of criminal proceedings. The nature of offense, the number of accused, the number of witnesses, the workload in the particular court, means of communication, and several other circumstances have to be kept in mind. It is neither advisable nor feasible to draw or prescribe an outer time limit for conclusion of all criminal proceedings. It is not necessary to do so for effectuating the right to speedy trial. We are also not satisfied that without such an outer limit, the right becomes illusory. Even apart from Article 21, courts in this country have been cognizant of undue delay in criminal matters, and whenever there were inordinate delay or whether proceedings were pending, where the proceedings were pending for too long and any further proceedings were deemed to be oppressive and unwarranted, they were put an end by making appropriate orders. Prescribing periods of limitation at the end of which the trial would be obliged to terminate the proceedings and necessarily acquit or discharge the accused, and further making such directions applicable to all the cases in the present and for future, amounts to legislation which in our opinion cannot be done by judicial directives and within the arena of judicial lawmaking power available to the constitutional courts, however liberally we may interpret Article 32, 21, 141 and 142 of the Constitution. The dividing line is fine but perceptible. Courts can declare the law, they can interpret the law, they can remove obvious lacunae and fill the gaps, but they cannot entrench upon the field of legislation properly meant for legislature. Binding decisions can be issued for enforcing the law, and appropriate directions may issue, including laying down of timelines or chalking out a calendar for proceedings to follow to redeem the injustice done or for taking care of rights violated in a given case or set of cases, depending on facts brought to the notice of the court. Now, my lord, this court says this, my lord, which generally it reserves its own my lord, domain. This is permissible for the judiciary to do. Legislature cannot. But it may not, like the legislature, enact a provision akin to or on the lines of chapter so-and-so of the Code of Criminal Procedure. So legislature cannot. My lord, here also, I think, my lord, the provision was deemed acquittal or something. My lord, it was judgment of the Supreme Court which put time limits.
Right.
On completion of the trials, and the
Many benches.
my lord, recently in Allahabad High Court, my lord, judgment also, my lord, where the my lord, that Asian resurfacing judgment that it will have to be decided within 6 months or interim order will be deemed to have been vacated.
That is reviewed.
Yes.
That is recalled.
That's recalled by a 5-judge bench. 5-judge bench. Lord, here the judgment said judiciary's power is untrammeled, Lord, as per all the judgments, that if it is not decided within 6 months, the interim order is deemed to have been vacated. We are also dealing with, my lord, similar situation where it is deemed assent, etc. My lord, I'll come to that.
Outer limit at all. Your question is, isn't there an outer limit? Can the constitutional interpretation be left to a vacuum? Creation of a vacuum, a long jump.
My lord, there are two answers.
Jump by. Of course, we have had that there's nothing like a pocket veto. Just keep it and don't respond. That's not permissible. But though we can't specify a time limit. But at the same time, there must be some way in which the process works out. Can it be a situation where not acting on a bill which is sent to the governor
No, that is,
itself is a full stop, no further, is it?
my lord, I'll answer it. in-
Where we need your assistance.
Yes, my lord. I'll answer, my lord, in two ways. A, what your lordships very rightly, my lord, feels pained at is a justification for fixing time limit, but will not confer jurisdiction to fix time limits. Number two, if that is so, Lord, we are not flooded with cases where, my lord, such situations have arisen. Lord, there are instances where, Lord, one or two states have come, my lord, with such situations. If that is the problem, and that may be the problem, the remedy lies with the constitutional framers, my lord, with the parliament. The parliament will have to be done. Your lordships have said time and again in several judgments that in view of this, we request the parliament. Your lordships never direct. Your lordships never direct, coordinate constitutional functionary. Even if the notice goes to a constitutional functionary, your lordship's registry's form is also different. You are called upon to remain present is not there. You are requested to put your appearance because that's the constitutional committee. Lord, your lordships have said in large number of cases that desirability of the parliament to consider this. But the practical answer, my lord, if I were to, my lord, assist your lordships, is the political